Going back to winning isn't easy. Let's talk about two more mistakes in the initial application. It's doing stuff you shouldn't be doing and staying on social media, and then an experienced ERISA disability attorney represents you. You've heard many times about why you should not be on social media. Social is one of the first things that lawyers are going to look at in your during the course of the case. What they're looking for is doing stuff you shouldn't be doing because your doctor told you not to do it, or stuff you said you shouldn't be doing and you're doing, particularly as documented on social media. Now, I once had a client who claimed that he was disabled from working because he had migraines as a result of looking at a computer screen. The disability carrier caught him on a gaming site and actually recorded him on several occasions participating in doing gaming activities. They took that information back to the treating physician and asked the physician whether the physician remained of the opinion that the claimant was unable to engage in computer work. Obviously, having had an opportunity to review the surveillance, the doctor not only retracted his opinions, affirmatively opined the claimant was capable of working and performing his occupation, and the doctor fired him as a patient. You can only imagine this case did not go well. So please turn off your social media. Tell your relatives and family that you don't even want to be tagged in any kind of activity. That will kill your case and can be practically impossible to fix. Now, another mistake is not having an experienced ERISA lawyer represent you. Now, just because you fill out the application doesn't mean you should. You're going to make mistakes by not getting the disability policy or plan, not understanding what you have to prove, not reviewing your medical records, picking the wrong day to be disabled, completing the paperwork in a fashion that will give the disability carrier plan a reason to deny your benefits, being on social media. Any of these errors, individually or in combination, can result in a delay or denial of your benefits. And worse yet, you can make mistakes if that claims representative wants to speak with you. Talking to an adjuster is like talking to Freddy Krueger. Now, I will tell you, I know that people are sometimes reluctant to hire lawyers because obviously we charge. But I will tell you, if you've been scheduled for an interview with them, if you've been scheduled for a consultative examination, you're being set up for a claims denial. You need representation, certainly at that point. But in my view, before you stop work and apply for benefits, you should be talking to someone like myself who can review your policy and explain what needs to be proven, review your medical records and explain if those records support your claim or not, develop a strategy to get your benefits, help you pick the right date to claim you were disabled, interact with a disability carrier plan on your behalf, provide the disability carrier plan with favorable evidence from your employer, your family, your friends, your doctors, develop as appropriate necessary medical information, including perhaps a functional capacity evaluation or an evaluation by a favorable doctor, develop appropriate vocational information explaining why you can't perform the material and substantial duties of your occupation, submit financial documentation that supports your claim the date you picked as being disabled. And if your claim has been denied or they're slow walking this claim, obviously it's time to get an attorney, particularly if that claim has been denied, because you're only going to have 180 days in which to file an appeal, which is the trial of your case. Abraham Lincoln once said that a person who represented themselves had a fool for a client. And you should be, again, talking with a lawyer. Many lawyers, such as myself, offer a free complimentary consultation, and we handle these claims on a flat fee or a contingency basis. So, in other words, if you don't get your benefits, we don't get paid. I strongly believe that going it alone should not be your course of action. These claims are complex. They require legal and medical expertise to navigate the process so that you get the disability benefits you deserve. I want you to understand that I come from a family of a disabled breadwinner. My father, who was a pilot during World War II, came back after the war, went to work with our family insurance agency, brokerage business, and he purchased a disability insurance policy. Ultimately, and unfortunately, he became disabled, and our lives were turned upside down as a result of his disability, changed our financial circumstances, plans for college, all sorts of things got upended. And he took that application very seriously. Now, he was an insurance agent and he understood how to fill out an application, but you probably aren't an insurance agent and you probably aren't an ERISA disability attorney. We think that you owe it to yourself to consult with experienced ERISA disability attorneys, regardless of where you live in the United States, before you make a crucial mistake on your initial application that can be impossible to fix. Got it? Well, I hope that you have enjoyed this week's episode of Winning Isn't Easy. Please like our page, leave a review, share it with your family or friends, and subscribe to this podcast. That way you'll be notified every time a new episode comes out. I hope you tune in to next week's episode of Winning Isn't Easy. Thanks.